Ultimately, looking at the facts and factors in this case, all the relevant legal factors, I'm sentencing Mr. Stackhouse as follows. On count one, I'm ordering him to serve 15 years of initial confinement and 6 years of extended supervision. That's the maximum in custody upfront time on a second-degree reckless homicide. It's absolutely, totally, completely warranted in this case. On count two, I'm sentencing the defendant, and count one, by the way, is consecutive to count two, consecutive to count three. On count two, neglecting a child where the consequence is bodily harm, I'm sentencing the defendant to 3 years of initial confinement, 1 year of extended supervision. That sentence is consecutive to count one, consecutive to count three. And on count three, I'm sentencing the defendant to 2 years of initial confinement, 1 year of extended supervision. That means it's the court's specific intent that the defendant serves a total of 20 years of initial confinement, 8 years of extended supervision. Under the totality of the circumstances, everything I've already discussed, the upfront time with the significant amendment, the upfront time needs to be very close to the maximum. 20 years of initial confinement, 8 years of extended supervision. In this case, I'll give the defendant the credit for in custody time, which is approximately 2 years.
739.
739 days of credit. The 739 days of credit will be applied against count one. Again, counts 1, 2, and 3 are each consecutive. Conditions of extended supervision are as follows. But first, let me ask, is the defense stipulating to the restitution the $5,000?
Yes.
All right, I'll order the restitution in the amount of $5,000. It's to be paid to the Crime Victim Compensation Program. While in the institution, I'm authorizing the maximum amount be taken out of the defendant's in custody earnings, wages, funds, or monies of any sort to pay first the restitution and then costs, fees, and surcharges. Any restitution or costs and surcharges that are not paid while the defendant's in the institution are to be paid while he's on extended supervision. Conditions of extended supervision are as follows. First of all, Mr. Stackhouse is to seek and maintain full-time employment. He's to complete either in or outside of the institution an anger management class and a parenting class. I cannot think of a possible class or classes more necessary. Anger management and a parenting class either in the institution or when he's on extended supervision. Mr. Stackhouse is to maintain absolute sobriety. That means no alcohol, no illegal drugs when he's released. I want the DOC to perform random drug tests on Mr. Stackhouse while he's on extended supervision. I'm not imposing a fine in this case. I am ordering the restitution, as I said, based on the stipulation and based on what the state proposed and requested in the amount of $5,000. I am ordering the defendant to pay all costs, fees, and surcharges, both mandatory and non-mandatory. Again, if it's not paid in the institution while he's on extended supervision. Failure to pay while under the court's order would result in a civil judgment subject to collection, forfeiture, and tax intercept. Due to the nature of these offenses and my own personal determination, the defendant is not eligible for the challenge incarceration program, not eligible for the substance abuse program. I will provide the defendant with a written explanation of the court's determinant sentence. Mr. Stackhouse, in this case, you have the right to appeal. An appeal would have to be filed within 20 days. Understand that?
Yes.
Yeah.
Because this matter is a felony, you're not allowed to vote in any election. You're not allowed to vote in any election until your civil rights are restored. They will be restored, but until then, you're not allowed to vote. You understand?
Yes.
You're also not allowed ever for the rest of your life to own or possess a firearm, a gun. If you live to be 95, you're still not allowed to own or possess a firearm. You understand that?
Yes.
Mr. Torbenson, anything I left out from the standpoint of the state?
No.
Defense?
Oh, Your Honor.
All right, then we're adjourned. Thank you.
Yeah. We could copy this. Good day, Judge.
See ya.